in the matter of Centrica Overseas Holdings Ltd, the Commission is to hold His Majesty's New and Hospital.
Mr. Hewitt. Good morning, my lord. I was going to deal first with a few points that arose from yesterday and then just finish off on expenses of management. The first point is concerning the form of the transaction, the form that we discussed yesterday, the precise form the transaction in fact took. And I just wanted to show you a couple of paragraphs in the findings of fact in relation to this, which I hope makes the point that I was making yesterday. And then I want to show you precisely what the transaction was, because in the end. So first of all, paragraph 130 of the First Tier Tribunal decision. This is a slightly more detailed description of the point I was making yesterday about the way that Centrica saw the sale process. Paragraph 130. List in the court. Mr. Recording's successor were senior people in Centrica's M&A team, were focused on business as opposed to legal entities. They saw the role of the M&A teams obtaining the maximum value for the OXO businesses in whatever way was feasible. They recognised that lawyers would be doing some corporate plumbing to complete the transaction, but the aim was always to realise the value of the business. And then they make the point that in the end, COHL received the value by way of repayment of loans, but not by selling the BV company which it owned. And then 137.
Sorry, just before you leave 130, I had noticed the phrase corporate plumbing.
Yes.
And thought that might be of some interest.
Yes.
Not just because it's a colourful phrase, but it may actually have some legal relevance, because if one thinks of actual plumbing and how expenditure on that would be treated, it may give us some insight into how corporate plumbing should be treated. Yes,
although I think the point I'm really drawing out of this is that they saw that just as being the mechanics.
Sure, I understand.
So the same point really comes out of 137. It was stated the parties intended to achieve an economic and operational outcome that would be as close as possible in nature to a transfer of the shares in OXO BV. Acknowledge the terms would have to change. And then if you just turn back to 115, you'll see how this happened in relation to Debro. 115. Debro produced a document dated 12th November 2010, Project Horizon Step Plan. This contained a detailed explanation of all the steps which need to be taken to achieve the proposed demerger, including the creation of the new companies, transfer of assets to them, the regulatory and legal processes that are required, right up to the registration of the buyer, shareholder, register OXO meetings, which Mr. McCord called the detailed corporate plumbing that needs to happen. So that's what he's referring to. This very much transaction-focused document. In fact, the demerger took place was slightly different from the process in the step plan. And then, if we could just look at what actually happened, and for this purpose, this is the only time I think I'm going to do this. I want to look at a document in the supplementary bundle, because it's a very useful. It's behind tab 9. Page 41. It's a very useful diagram of
I'm sorry, which page?
It's page 41, behind tab 9 in the supplementary bundle. I hope you've got a document like this, which has got it's a diagram of the various companies. And along with that, so that was the position before the transaction took place. Now, what then happened, and you'll find this in the findings of fact at paragraphs 28 to 29, but if I just tell you, the left-hand company, OXO Netherlands, it formed a new subsidiary, and some of the business was transferred down to the new subsidiary, and that was sold then by OXO Netherlands BV to Eneco. OXO Tolling was kept, if you remember, it didn't go. OXO Metering was sold directly to Eneco. And the final company, it formed a new subsidiary, which they refer to as the merged company B in the findings. And there was a transfer down of the business to that, and that was sold to Eneco. So that's, to be precise, that's precisely the mechanics of what actually happened. I won't repeat what I said yet, but we say it doesn't make any difference to the nature of the expenditure. As regards PwC's fees, there was evidence before the FTT. I think it was in cross-examination. We found it in the transcript that they did charge by the hour, hourly rate, for the work they did. There were also interim bills, so that I think the bill in the bundle may not be the only bill. There were earlier bills, and I think to just complete that, I ought to point out that it's recorded in paragraph 128 of the First Tier Tribunal decision that there was a pause while they did the deep dive, and then they decided to carry on with the sale. You'll find that in paragraph 128. There was also a pause, also recorded in the findings of fact, because the local employees had to do the statutory accounts for the companies. So there was a period when they were too busy to really be involved in the sale. But those are the two times when there was a pause. I said yesterday that Eneco's offer of January 2011, I think I said was accepted in principle by Centrica in February. To be completely accurate, what actually happened was it was approved by the board of Centrica, and the board delegated certain senior officials to negotiate the deal at that stage. So I don't know what was communicated to. I don't think we was told exactly what was communicated to Eneco at the time, but that's what the findings of fact say, and that's paragraph 123 of the First Tier Tribunal decision.
Centrica being the head company, DLC.
Yes, Centrica is the top company, which I think had the employer was doing things. But anyway, it was the board of the top company because they were taking the decisions as to what would happen. Yeah. Just a very small point. What was said about the vendor disclosure document? I mentioned that. What was said in evidence was that it was not, by Mr. Accord, that it was not uncommon but not standard to have such a thing. I'm not quite sure why. That's paragraph 95 of the First Tier Tribunal decision. And then can I then turn to ECC quarries? And first, can I just take you to another case, which I didn't take you to, but it's in the bundle, which is, I think, relevant, which is a case called Pendleton, which is about licenses, pub licenses, transfer of pub licenses. And it's tab 16. It is in fact cited and applied in ECC quarries. What this was about was a situation, I think, in Birmingham where in order to get a new license for a premises, it was necessary to give up an equivalent license somewhere else. So there was a process, and that involved proceedings where they had to go before, I don't know, the justices or somebody, and get the license removed from the old premises, and then a new license granted. They talk about, in this case, a transfer of the license, but I think strictly speaking, it wasn't the same license that was being transferred, it was actually a removal. And there were objections. I get the impression from reading this that the objections were mainly in relation to the removal of the license rather than the grant. I think those didn't want to lose their pubs, presumably, or whatever. But anyway, they had to take proceedings, and the question was whether the costs of that were capital. And there had been earlier cases. You'll see on page 300, they refer to a case called Southwell and Saville, and in a case called Morse and Stediford, where it had been held that these costs were capital. And if we just look at the decision in this case, paragraph 30, page 302, if you just read from the Crown submitted, because then they give the Crown submissions, company submissions, and then the decision, which was to accept the Crown submissions, you'll see from the first sentence.
So you'd like us to read the 3 paragraphs?
3 paragraphs, yeah. So you can see that there has been a line of authorities previously where legal expenses have been in dealing with something equivalent to an asset have been able to be capital.
Yes, and I note that at least in the Crown submissions against letter C, there is a suggested analogy between the costs of the bricks and mortar and the costs of obtaining a license.
Yes. Yeah.
And it might be said, I don't know, it might be said that that's where the plumbing analogy may come in.
Yes. So, as I say, that's the case, and then that was cited and applied in ECC Quarries at page 325. You will see they refer to Pendleton's and explain it. They say these observations, it seems to be very appropriate to the submission that all the company was taking in the present case and making planning applications to secure the continuity of its trading operations, i.e. rejecting that argument thing. And then he does point out that the analogy is not precise because you can't transfer or sell planning permissions with licenses. Could be different.
I was just going to observe, I mean, these are both decisions of very experienced Chancery judges, Mr. Justice Cross and Mr. Justice Brightman.
Yes, exactly, yes.
Both of whom future law lords.
Yes, exactly. Yeah. Who knew a thing or two about this area.
Yes. Yeah. And just on the point about planning permissions, I don't think it's going to matter in the end, but certainly my understanding is that a planning permission is, certainly it's not personal, because in fact you don't even have to be the owner of the land to make the planning application. You can make it, sometimes companies do it, development companies do it as a matter of speculation. But more importantly, as I understand it, it is something which has to feature on the land register. So it runs with the land.
Yes.
In the case of unregistered land, it used to have to be on the land charges register.
Yes. We've looked into this.
I'm sorry.
Section 75, I was going to say Section 75 of the Town and Country Planning Act 1990, Section 75, 1 provides that planning permission, any granted planning permission or permission in principle to develop land shall, except insofar as the permission otherwise provides, inure for the benefit of the land and of all persons for the time being interested in it. That's what it says. So you're right. You're right, Lord.
I mean, as I understand it, analytically, what's going on here is that if we take a case like ECC Quarries, what Mr. Justice Brightman is saying in essence is, even on his analysis, which may not have been entirely accurate, but I don't think it matters, even on his analysis, a planning permission is to be regarded as an intangible asset. That's your ultimate objective. Use Mr. Justice Dixon's words in Holster. What is, from a commercial point of view, what are you trying to achieve? Mr. Justice Brightman says, what you're trying to achieve is the grant of planning permission.
Yes.
And then the second step of his analysis, as I understand it, is that expenditure on not just the planning fee, but in the run-up to that, things like your lawyer's work, and maybe your planning consultant's work, all the expenditure which you incur in seeking to obtain that asset is also capital expenditure.
Yes, that's right.
And I think the third stage of the analysis that you urge us to adopt, whether it's right or wrong, I don't know, but what you urge upon us is that there can be no analytical distinction of any relevance between the acquisition of an asset and the disposal of it.
Yes.
And so if you flip those two around, if the end objective is to dispose of a business, then the cost of the various steps that have to be taken to achieve that,
or are taken,
you say that must also be capital.
Yes, and I would rely on. I mean, Tucker summarises the position. I think that it's the acquisition, the disposal, or the improvement of a capital asset. Those are the clear cases. Right. The difficult cases are where there's an enduring. It's argued there's an enduring benefit of something that's not an asset, but is similar to one. We've looked for other cases in which ECC Quarries. It has been cited in a number of cases, not on that exact point, but on the point of abortive expenditure being capital because it's abortive. But it's also been cited in relation to accountancy because of an accountancy point.
Yes.
In it. And my Lord Justice Singh may remember, I don't know, there was a case you were involved in about 2000 about the Halifax Building Society.
Yes, I do. Yes.
Yes, where ECC quarries featured.
I see. That I'd forgotten.
Yes, it wasn't a big point, but it featured in relation to 2 points, whether it had to be a balance sheet item to be capital, and it was said no, and ECC quarries was given as an example.
Yeah.
And also whether abortive expenditure could be. That was another point that was raised.
Yeah.
ECC quarries was relevant. In fact, in that case, the costs of conversion of the building society were held to be revenue.
They were.
Because they didn't produce the capital type of enduring advantage. They produced an ability to trade more effectively.
And my recollection is there was no appeal then.
I don't think there was.
No, I don't recall.
No, it was a special commissioner decision. Yeah.
And on the abortive expenditure issue, of course, CAMAS, I suppose, is now the leading authority. That doesn't make any difference.
Yes.
Nobody suggested in that case
No.
it made any difference to the analysis that the rejected takeover of Appellant fell by the wayside.
No, and it can't. When you think about it
No.
for a moment, it can't possibly make any difference whether it goes ahead or not. The expenditure is the same. What it's on is the same, whether you achieve it or not. The other point that Mr. Justice Cross makes at the end of this decision, you'll notice, is that you can't see how it makes any difference that there were hundreds of these. Hundreds of capital transactions are still capital transactions. So that was all I was going to say. As I say, we couldn't find any cases where it was being applied in relation to the point on the professional fees. That just seems to be assumed. As I can see, nobody's ever raised the point. Yeah. It was applied quite directly, the decision, in a case called Market Southwest Holdings by the Upper Tribunal. But, I mean, it was assumed to be correct and just applied.
No, that's very helpful.
Yeah.
It would be of particular interest for us to know whether it's being considered by this court or by the House of Lords or Supreme Court for obvious precedent reasons.
Yes.
But it seems as if
Tucker
is the one.
Yeah.
I'm grateful to you and your team for doing that research.
So the only point I'm going to just deal briefly, I'm sorry I've taken more time than I thought, is finally on expenses of management, and just to wrap that up, so just to look at what the First Tier Tribunal, the Upper Tribunal said about that. So the First Tier Tribunal, paragraphs 320 to 330 are really the kernel of reasoning and decision. And they were asking the question, when was there a firm intention to sell? And they didn't regard the strategic decision to divest as being a firm intention to dispose of the building, of the business. They agreed with Mr. Rivet, in submissions at 329, that you had to get to the stage where it was an identified purchaser who the seller concluded as satisfactory. The price must be acceptable, the broad structure of the transaction must be agreed, the other terms must be broadly effective. In other words, the seller must have decided to go ahead with a specific transaction, the specific purchase on specific terms. So really the question in this case, I think, is that correct as a matter of law interpreting what's said in CAMAS? The Upper Tribunal dealt with that at paragraphs 97 to 104.
I'm sorry, which paragraph?
At 97 of the Upper Tribunal decision,
Yeah.
to 104. And in particular 97, where they say they accept that they decided they wanted to sell the business, publicised the fact Drubber's accounts on the basis the auction route would be treated as discontinued. However, the way in which it was going to achieve a sale and whether it was willing to proceed depended on what was possible and advice it received. The business would not be sold at any price and even necessary to close down the business. Centrica needed to appraise the business, understand what was going wrong, and identify how the beneficial sale could take place. We viewed the decision in June 2009 as a decision in principle. Many issues remain to be decided upon. Well, again, it's the same point, I think. Is that sufficiently firm decision to sell, to stop the action, stop what goes after that being expenses of management? But I just want to emphasise again that the question that we're asking here is a very different question to the question we're asking in the capital revenue. And even if it is decided that there is a very narrow range of expenses which are not expenses of management, and so in other words, expenses of management is very wide and only stops when you really get to near the end of the transaction implementation. That doesn't cast any light on the question of whether it's capital or revenue.
I mean, if anything, it rather shows the importance of the capital
yes,
provision as well. And
exactly.
May well be a very good reason why Parliament decided to enact it.
Yes, exactly. But also, it can't be right that whether something's capital or revenue depends on the answer to a completely different question, which is it an expense of management? Which is a totally different question.
Do you have any submission, you may not, but do you have any submission to make to us about what the nature of the expenses in Sun Life was? If at that time it had been important, it wasn't important to analyse it in terms of capital versus revenue. But what was on your submission?
Oh, I think they would definitely have been capital.
I thought you'd say that.
Clearly capital, yeah.
And that perhaps that just underlines the submission you've just made to us, that the court needs to be very careful to keep conceptually distinct the legal questions which arise on the question, is it expenses of management, as compared with, is it capital or revenue?
Absolutely. Yes. Unless there's anything further. Sorry, my junior's concerned as to whether we are, as regards to ECC quarries, is there anything further that you would like us to do in looking at other cases, or are you happy where we are?
I heard Mr. Henderson say that you were going to double check.
Yes,
That's
he's
a
very
good idea.
concerned.
But subject to that,
Yeah.
thank you very much, Mr. Ribbett.
My Lords, I thought it would help just to signpost where I hope to go over the course of the next few hours. The first thing I thought would be helpful to do would be to give your Lordships my answers to the points raised by Lord Justice Singh regarding the nature of the test to be applied before this court. The second was to make 4 introductory points, which I shall do. Then I propose to turn to the legislation. Then I'd like to take you, with your leave, through the findings of fact. In some detail, I'm afraid, because I think that they are absolutely central in my submission, for reasons we'll come on to, and there are a number of passages that we haven't looked at in detail. Then I propose to deal with expenses of management and then capital, to reverse the order that my learned friend did, simply because, to make the obvious point, which I will make in due course, in understanding the nature of that capital expense which is excluded by the provision here in question, in my submission, the court needs first to understand the scheme of the legislation and to construe it in its proper statutory context. Simply starting the analysis from an assumption that you can wholesale apply all of the principles from authorities arising in a different statutory and common law context to these provisions, in my submission, is the wrong departure point, for reasons I shall make good in due course. So to deal with the first aspect, which is dealing with the questions raised by my Lord Justice Singh, the court will have in mind that there are 2 grounds of appeal that have been raised by HMRC. The first, did the Upper Tribunal err in deciding that the disputed expenditure constituted expenses of management within section 12191? we submit there are two bases upon which that can be challenged before this court. The first is, did the Upper Tribunal err in law in its identification of the test as to what constitutes expenses of management? That's a question of law. The second, if the Upper Tribunal identified the correct test as to what constitutes expenses of management, then did it on the facts that were found by the FTT err in law in finding that the FTT was entitled to find that this constituted expenses of management? That is to say, that also raises a question of law, but the threshold is not whether or not the tribunal would have reached the same decision, but whether the FTT was entitled to reach the decision that it reached. I understood my learned friend to put his case solely on the former point, namely, the question as to whether or not the Upper Tribunal had accurately identified the test as to what constituted expenses of management. There is no separate Edwards and Bairstow challenge. And for reasons I will expand upon in due course, I submit that that causes my learned friend's case some difficulties. To foreshadow where I will go with that, in our submission, the Upper Tribunal was right to identify that the FTT did not err in law in its identification of the test. And we submit that should be the end of the issue. Ground 2 is the question as to whether the Upper Tribunal erred in law in deciding that the disputed expenditure did not constitute capital expenditure, so as to be barred from relief pursuant to the provisions of Section 12193 of the 2009 Act. It is, I think, common ground that the construction of Section 1219 subsection 3 is a matter of law. It is also common ground that the identification of whether a given expense is of a capital nature as properly construed in that context is also a question of law. But that test must be applied on the basis of the findings of fact which were made by the fact finder before the tribunal. That's clear from Beecham and Woolworth. And in these circumstances, we will submit that the Upper Tribunal was right to identify that the test in Section 12193 does not simply import whole scale. The historic capital and revenue cases which we're considered in the context of trading context, but must be construed properly in its statutory context. And I just put down a marker in this regard, which I hope to make good in due course. I will say that in substance, what my learned friend did yesterday in a number of respects in looking at the FTT decision was not to identify whether or not the tribunal had identified the test correctly, but instead to look at certain findings of fact and to say that the FTT should not have made those findings. But if I may, I'll come on to that in due course. I then wondered if I might make 4 big points at the outset before turning to the scheme of the legislation. And I will develop these in the course of my submissions, looking at those and also at the authorities that follow them. The first point to make is that the authorities make plain, and the scheme of the legislation makes plain, that the purpose of the relief contained within the provisions here in question is to put investment companies on an equal footing with trading companies and to ensure that they were taxed in accordance with their economic profits. And we'll see that the authorities explain that. And I make an obvious point here that absent relief under Section 1219, my clients cannot deduct that expenditure and as such would not be taxed upon their economic profit in these circumstances. It may be said against me Oh, but that's because you did not dispose of the shares. And so there was no CGT disposal against which you could offset the expenditure. But for reasons I will develop in due course, I submit that it is of the very nature of investment businesses, and in particular, investment businesses of the type here in question, in which regard the FTT made detailed findings of fact we'll turn to in due course. But acquisitions will be contemplated that do not take place, and that disposals will be considered that do not take place. And furthermore, when in due course we come to have a look at the scheme of the capital gains tax legislation, the court will see that the category of expenses that may be deducted in computing the CGT charge are narrowly circumscribed in a manner that would cause difficulties in these circumstances for any deduction, bearing in mind the findings of fact that the FTT made about what the expenditure was actually on.
But in that respect, investment companies are in just the same position as trading companies, aren't they? I mean, trading companies can't deduct capital expenditure, and if they make disposals for CGT purposes, they have to put up with the law on allowable deductions.
Well, that is certainly the case, my lord, but the difference is that trading companies, it is not of the essence of the business of a trading company that they spend their time contemplating what to do with their investments.
I'm not sure if that's right. I mean, they will have assets held on a capital account. Then may well be a matter of very ongoing importance to them as to how they monitor the economics of that investment and decide whether or not it should be changed.
Well, perhaps I could deal with that. May I come on to that
Of
in a moment, my
course,
lord?
sorry,
I'm very aware I need to answer the
your point. I
question.
was just making a...
Yes.
The observation I made was really directed to your point that the aim was to put investment companies in the same position as trading companies, mutatis mutandis.
Yes, yes, ma'am. But in a sense, I take that from authority, so perhaps I might respond in due course. Sure. Second, we say that the effect of the appellant's case is to squeeze the operation of this relief in two separate ways. The first, we submit that it restricts unduly the category of expenses that will constitute expenses of management of an investment business in a way which is wrong and incompatible with the authorities of Sun Life and Cannan. And secondly, it expands unduly the category of expenses of a capital nature that will fall within the exclusion introduced by section 1219 subsection 3. And for reasons I will come on to develop, we say that the provision in section 12193 must be construed in the context of a code which is designed to give relief to companies with investment businesses, and to make the obvious point that it is of the very nature of an investment business that it will be involved in the decisions regarding buying, holding, selling of investments, and the management of decisions regarding that. And in this regard, I just make 3 points regarding what I submit is the violence that the appellant's case does to the scope of the relief here in question. Again, picking up on a point that was raised at the outset by my Lord Justice Singh. First, and I make no point about this, but it is noticeable that for the first time yesterday, having laid down the gauntlet before the FTT and before the Upper Tribunal, and in our skeleton argument, my learned friend responded to a question from your lordships and said squarely, as I had expected he would do, that the effect of section 1219 was to reverse Cannan. But that is not a submission that has been advanced below. That is indicative of the next 2 points that come to show the extent of. The second, illustration that one can take as to the violence that this does to the scope of the relief contained within these provisions is my learned friend's reliance upon the decisions of the courts in Sargent and Ayres, and then ECC and Watkins, and said that on the basis of those authorities, that type category of capital expenditure would be excluded from the scheme of the relief here in question. Now, for reasons I will develop when we come to look at the case, Sargent and Ayres shows you quite how high my learned friend puts his case. Because as I will develop by reference to the facts of that case, there, the expenditure in question related not to the costs of an exercise identifying a particular farm in Australia. It was an exploratory trip to Australia to have a look at farms generally in Western Australia. And in my submission, that is precisely the type of expenditure which falls squarely within the scope of the relief here in question, in the context of an investment business. And I'll come on, if I may, to make that good in the context of the scheme. The final point to make is this, and I really make it as a matter of fairness to my clients. My learned friend was asked by Lord Justice Singh what scope his construction left for the relief. The instinctive answer that was given was that £26 billion worth of relief is afforded by HMRC each year under the terms of these provisions. That's the first part of his answer. Now, just making the point in response to that, with the greatest respect to my learned friend, the law of England is, as matters stand, and until this court decides otherwise, that these expenses may be deducted. And so we cannot know from those figures whether or not those tax returns have been based upon a law consistent with the findings of the courts below in this case, or otherwise. We cannot know the extent or the basis upon which those figures have been derived, and we cannot know the extent to which relief claimed in these circumstances has been inquired into or challenged. I mean no criticism to my learned friend when I say the point, but with the greatest respect, numbers, I'm not sure an answer, well, you'll still get £26 billion of relief in the event that the Court of Appeal decides this in my client's favour, is an entirely satisfactory response to what I think is a legal question. The second point to make in relation to that was that the second component of my learned friend's answer was to give two illustrations of expenditure that would be allowed. With respect, there is a danger which is beset from all of the authorities in arguing any case by reference to analogy or facts, because the circumstances of each individual business will differ radically. And that's the one message that unites all of the authorities. But it is noticeable the two examples that were given by my learned friend were employment costs, which were described as obviously falling within management expenses, and then rent. Now, taking the first of those, by the end of the afternoon, my learned friend was saying that certain employment costs were not deductible. And then, when we came to look at the authorities, it's clear that the question of rent and payments and premiums is not quite, but would equally, in my submission, not yield quite such a straight example. And so, my hesitation in approaching learned friend's cases, I'm still trying to articulate where the bright line of principle lies that articulates what the edges of the exclusion are in section 1129.
Just on that, the second limb of what you were saying, as to rent, what do you have in mind there?
If we look at the authorities in due course, my lord,
Yes.
one of the authorities...
And come to them in due course
Yes.
rather than now. But
The short point is this, that you'll recall the words of my lord, forgive me, I remember which judge it was, discussing that the only difference between a premium and a rent in certain circumstances was the period over which it was paid, and it may differ in those. So it's the tax treatment that determines the qualitative nature of the difference between those two sums, which seems to be one of the points that was being made. And so, in a sense, perhaps obviously, it may be the case that rent, because it has the nature of recurrence, may be a typical example of an income expense or receipt. I'm not sure it can provide the bright line, because there may equally be circumstances in which the headquarters of an investment company pays rent, which, on my learned friend's case, I think may fall on the capital side of the line. I can't see a principled basis for distinguishing that from the premium.
I mean, I follow that the rent premium type distinction looks a bit
Odd.
arbitrary, possibly. But is it not more the case that the position of the premium looks potentially anomalous rather than the position of the rent?
Quite possibly, my lord. In a sense, I think what it may, I hope in due course to identify what I submit is a principled basis for construing section 1129 subsection 3, which doesn't rely upon isolated examples in different types of business as to what may or may not be deductible, and aims, I hope, to offer the court a principled basis for construing the provision. My concern, and it's with no disrespect to my learned friend, is that as matters stand, HMRC's case proceeds by reference to example, and the court is called upon to articulate a principle so that taxpayers have an opportunity to understand clearly which side the line falls on, but also, in a sense, so that Parliament can understand which side the court has interpreted the line to be drawn on, so that if Parliament disagrees, it can do something about it.
I mean, if the revenue were right, the underlying test is, in a sense, very simple. It's just you apply the century or more authority on the question of what constitutes capital, which everybody now has to agree is a question of law. And looking for bright lines in that morass of authority, I mean, one would love to find them. It's often a difficult search.
I was going to say, my lord, I think the pupils at Fancourt would be delighted to know that an income capital question was here.
Well, that may be so. I mean, this case is a Fancourt, as far as I can see. But, I mean, seriously speaking for a minute.
Of course, my lord.
I mean, that is inherent in the nature of the capital income divide, which, like it or loathe it, has been part of the income tax scheme for a very long time indeed. So it's not inherently improbable that Parliament should have decided to import that, for good reason or bad, into the context of expenses of management.
Well, my lord, in due course, my submission is going to be that, with the greatest respect, it is inconsistent with the purpose of relief to have included an exclusion of the dramatic scope that my learned friend advocates for it.
Yes, and what I think I will find particularly helpful is how you can articulate that purpose in a way that doesn't just, so to speak, beg the question.
Of course, my lord. Yes.
Which is always the problem with alleged purposive constructions.
Yes, my lord.
Sorry.
Sorry.
But just before you move on, you were making points about employment costs and rent. What you can't say, can you, is that the, as you would say, overly expansive approach to capital that Mr. Ewan takes would render expenses of management incapable of having a role. There would still be things that would be deductible as expenses of management.
But, my lord, I don't know the answer to that. Because if one has a look at the nature of the facts that were found regarding the business here in question, the difficulty with it is, at one level of abstraction, taking the extreme ECC and Watkins case and construction of that, as it happens, I have a number of points to make on that as well, my lord. At one level of abstraction, all of the costs of running an investment business are concerned with capital assets. That's what investment businesses do. And the question is, where does one draw the line in identifying what Parliament intended to exclude by provision, which, as my Lord Justice Singh identified at the outset yesterday, proceeds by way of exception to the Code. I think at that point, I'm going to come on in due course to deal with the facts in some detail. But I think probably the starting point may be to start with the legislation, if I may. And if I could ask the court, please, to return to that. I know we've looked at it. I hope that what I'm about to say, much of it should not be controversial. It was simply that it sets the frame for the submissions I'm going to make in due course regarding Sun Life and Camas. So behind tab 8. The starting point, as my learned friend said, is that this is a chapter which is concerned with companies with investment business. It deals both with companies that are pure investment businesses and, following the amendment, also companies that partly have investment business. And just a survey of the scheme of the regime that's contained within Part 16. It is something of an engine room for the collection of provisions that deal not merely with the identification of those types of expense that will be deductible, but also with the manner in which and timing in which deductions will be given. It also contains a number of fictions deeming provisions to constitute expenses which fall within it. And so, as it were, this is not some esoteric deduction. It is at the absolute forefront of the parliamentary machinery as to how it intends to afford relief to these types of companies. The second point to make is a point that my learned friend took you to yesterday, my lords. Company with investment business and investment business. In this part, company with investment business means a company whose business consists wholly or partly of making of investments. And we'll come on in due course to have a look at how the FTT identified that and identified the nature of the business here in question. And then if we turn to section 1219, in calculating the corporation tax to which a company with investment business is liable for an accounting period, expenses of management of the company's investment business, which are referable to that period, which is, if I may say so, a conspicuously elastic term for a piece of tax drafting. But there is we come on to see how that works out in due course, are allowed as a deduction from the company's total profits. A deduction under subsection 1 is to be made before any other deduction in step 2. For the purposes of this section, expenses of management are expenses of management of a company's investment business so far as A, they are in respect of so much of the company's investment business as consists of making investments. Again, another piece of elastic drafting. What it does not say is to import the test as you've heard described before in the context of the trading code, wholly and exclusively. And B, the investments concerned are not held for unallowable purpose during the accounting period to which the expenses are referable. Just pausing there, the unallowable purpose, if we turn to section 1220, these submissions, I hasten to add, are simply to set the context of the legislation, its framework. This is one of the outer walls of the relief. And this identifies circumstances in which you have something which, on the face of matters, may be an expense of management, but which the draftsman has said you can't claim a deduction for because you incurred that for an unallowable purpose. And those purposes are the business or commercial, other than a commercial purpose of the company, or for the purposes of activities in respect of which it's not in charge to corporation tax, or in circumstances where they've been held directly or indirectly or in connection with any arrangements of securing a tax advantage. So there's an anti-avoidance provision brought into it as well. And then we look at 1221, amounts treated as expenses of management. And this brings in a list of expenses which on the face of matters might not be considered to constitute expenses of management, but are deemed to be so. I make these points for perhaps the slightly trite submission that viewed in terms of the scheme of what these provisions are entitled to relieve, and in terms of the terms in which they're drafted, before we get to the capital restriction, the language is expansive. The category of expenses that are given are indulgent compared to those of a trading company. And the walls are policed by statutory provisions which say that these are the edges of where your relief can be claimed.
Sorry, I'm not sure what point you're getting from section 1221.
Well, 1221, in a sense, these are not. What I think I'm saying is that it is the centrality of the code for the deductions that are given to these types of businesses. I can't take anything from things that are deemed in or out of being expenses because there's a number of points there that, frankly, look odd. Or they don't look odd, but there's no principle that drawn from. Exactly. But this is the reason I make this point is that when we come to look at trading companies, things are rather the other way around. Because when it comes to trading companies, the departure point in computing the profits and losses of the business is the accounts, and then subject to statutory overrides. It starts from a very different starting point. This is a legal approach to the identification of expenses. And accountancy, as we'll see, comes into play in due course, but that is to do with principally the timing of the deduction, rather than whether or not you get the deduction in the first place.
And that's going to answer your point about what referable to means, presumably.
It will, my lord, yes. Thank you. In fact, I can turn to that now if that would be helpful. It's section 1224, my lord.
Oh, yes, thank you.
Again, this is not. I don't think any of this. The next bit should be controversial, but just to explain how the relief operates, because this will feed in due course into my submission that one cannot simply transplant into this code trading questions. Accounting period to which expenses are referable. Sections 1225 to 1227 explain which is the accounting period to which expenses of management are referable. And then it identifies that there are exceptions to it. Talks about the scheme of the accounts not drawn up. Interestingly, and I just put this for the sake of notes, if we look at page 57 of this, the scheme of this is that you get the deduction broadly in circumstances where it's in the period during which it's brought into account. If we turn to 1255, any reference in sections 1225 to 1227 to expenses of management being debited in accounts is to those expenses being brought into account in the company's total profit and loss account or income statement, or a statement of total recognised gains and losses, statements of changes of equity, or statements of items brought into account in calculating the profits and losses for accounting purposes. And the same in the subsection. There's another provision that provides for it. So that doesn't take me any further forward, other than to indicate that when we come to look at the trading cases, matters are the other way around.
In the sense that, I mean, this is using accounts, as you say, to determine timing. Mm-hmm. You say in the trading context, you use accounts for a more substantial purpose.
There you identify the profits and losses in accordance with GAAP.
Yeah.
There's a statutory provision that makes that clear, and then there's a series of statutory provisions which overlay that. So there's a legal adjustment to accounting position. Here, this is a legal test where the accounting is relevant to the timing of the deduction. Now, the timing of the deduction is, of course, important, particularly given the terms of my learned friend's case, because the point that's made, and indeed my Lord Justice Henderson, I think, was referring to this earlier. If I am right on my case, there may be categories of expenditure which are incurred along the path at a point in time prior to any acquisition or disposal, which may or may not happen at some point in the future. And the company needs to know at what time it can deduct that expenditure. Now, we know, because my learned friend took you to it yesterday, that once you get to an eventual disposal of it, the way in which the CGT code works, section 39, is to say, well, if you've already had your deduction under the management code, you can't get it again in computing the disposal costs. But the point I take from this is that in looking at the scheme of the legislation is drafted in terms that clearly operate to enable you, if I am right, to articulate when the deduction is claimed, irrespective of whether or not there's a disposal or otherwise. The whole scheme of it is it's at least consistent with my case.
Why isn't that so on Mr. Ewart's case as well? I mean, if you identify something as a capital item, well, you don't put it into your accounts. If it's not a capital item, it goes into your accounts, and then you get relief by reference to the period for which it goes into the accounts.
Well, the difficulty is that if one looks at, in fact, we might turn to it now, if one looks at the terms of the capital position, and it's really to return to the point that my Lord Justice Henderson was raising earlier, the circumstances, there's a black hole here, because the category of expenditure that you would be entitled to deduct from a CGT perspective if you make a disposal is narrowly crafted. But the category of expenditure that would be allowed on a Sun Life construction as to what constitutes expenses of management is not at all narrowly constructed. And the question is where, between that ground, the line is drawn in relation to the expenditure here in question. Just to make that good, I'm very familiar, I'm conscious the court is very familiar with this, but just to look at the capital gains tax mechanism. Tab 4, my lord. Acquisition and disposal costs, except as otherwise expressly provided, the sums allowable as a deduction from the consideration in the computation of the gain accruing to a person on the disposal of an asset shall be restricted to the amount or value of the consideration in money or money's worth given by him or on his behalf wholly or exclusively for the acquisition of the asset, together with the incidental cost to him of the acquisition, or, if the asset were not acquired by him, any expenditure wholly and exclusively incurred with him by providing the asset. Now, one of the interesting things about that is that that language, I'm not suggesting there is any connection between it, but your lordships will have in mind the language that's identified in Sun Life and picked up in CAMES regarding expenditure which is incidental to and the mechanics of the implementation of a disposal of an asset. There's no connection between the statutory language here that there's no necessary connection in the sense that I don't suggest that the draftsman of the Capital Gains Tax Code had in mind that language when identifying the category of expenditure that should be taken here in account. But the point that I make is that, in a sense, the category of expenditure that would be excluded on the basis of the concession made in Sun Life regarding the acquisition and sale of the assets and that which was incidental to it is actually reflected in the deductions that you get from a capital gains tax perspective as well. So if we drew the line where CAMAS and where Sun Life had drawn the line, you would end up with a position where you didn't get the expenditure prior, save insofar as, one was entitled to deduct the expenses of management, but if Sun Life, for example, is right in the concession that was made, the cost of buying and selling the assets is excluded from constituting expenses of management, then Sun Life would also exclude the stamp duty and the brokerage fees because they were a necessary part of that. But that would give perfect meaning. That's one of the answers that we give to the effect of what section 1219 subsection 3 is intended to achieve. There's another answer which I'll develop in due course as well. But one of the things that it's intended to exclude is the expenditure on the acquisition of the investments themselves, and those which is totally consistent with Sun Life. and Cannas.
Hang on, why would you need to have that carve-out if they're excluded under Sun Life anyway?
Well, because, my lord, in Sun Life, it was a concession that was made by the parties, which was cast into doubt by the judgment of the House of Lords as to whether or not the concession was rightly made. In Cannas, the judgment that's given by Mr. Justice Patton, on the face of matters, doesn't whittle down or restrict the category of capital expenditure there in question to that which was the subject of the concession in Sun Life. So if I were on the other side of the room, I might have been worried that the floodgates were going to be opened after Cannas in the High Court to the concern that investment companies were going to start reneging on the concession that was made in Sun Life. But that's only one component part of my answer, my lord. And I hope to make it good when we come to look at Sun Life and Cannas in due course. The second point to make in relation to this is just the point that my learned friend took you to yesterday, which is that it is not the case that you get a double deduction for any of this. That's clear from section 39 when we're there, but that's in the bundle as well if you need it.
That would help if you do have a disposal of an asset. But if it's an abortive venture...
You don't get any relief.
I'm sorry?
You get no relief, my lord.
Yeah, that's what I thought the answer would have to be.
And that's why we need this relief. Because in these circumstances, it's also worth bearing in mind, we'll come on to it in due course, there is perhaps a temptation to view the investment of my client as being the shareholding that it had in Oxio. Well, that's one of its investments, but by far the more valuable investments were the loans as well that it had in place as well. That was also part of its business. And the importance of that is not lost on the tribunal, particularly in circumstances where the shares continued to be held after the transactions here in question, and loan finance continued to be provided to the company after as the court will have in mind. The Dutch power plant was not sold. It was still a menace after these transactions.
Your reference to the loans just reminds me, before I forget, of a point I was going to make, which is that in a number of cases, the FTT says that your client effectively got its value from the transaction out of the repayment of the loans. Now, on the face of it, of course, repayment of the loan doesn't increase your balance sheet position at all. So, am I right to infer that these loans were otherwise going to be bad loans? Or might be, or... Well, I mean, this is not explored anywhere, but it's not self-evident that getting your loan repaid is going to actually improve your overall position by a penny.
My lord, if I may I give you I'm anxious to give you a precise answer to that, because I think we do have the financial statements in the accounts, so we can see the extent to which the loan appeared on the balance sheet in any event.
I see.
But if I may give you chapter and verse in a moment, would that be acceptable?
At any convenient moment. Sorry, I just wanted to mention that.
No,
I forgot.
my lord, absolutely. Yes.
Thank you.
Perhaps that might be a convenient moment, if we may, to turn to the two principal authorities on expenses of management. And Sun Life first. The starting point is really to make the point I just made to my Lord Justice Singh. In Sun Life, the departure point of the analysis of their lordships is that in those circumstances, the costs of the investments had been conceded not to constitute an expense of management. And so what proceeded, everything proceeded from the assumption that those costs were not expenses of management, and the question was then the proximity of the brokerage and stamp duty cost to those. And if we turn first to, we turn to page 352.
Sorry, which page?
Forgive me, my lord.
You're
Okay.
using
It's
the report.
191 of our bundle. Forgive me. It's the report page 352. And Lord Simons. The facts are set out, which you've looked at already. It's worth just on page 193 internally identifying a passage where His Lordship identifies the special commissioners in disallowing the claim expressed their opinion in a way that I find helpful. They said, and we so hold, brokerage and stamp duties payable on the purchase of an investment, being not general expenses of conducting the society's business, but expenses specifically referable to and only incurred by reason of the purchase, are expenses of the purchase and not expenses of the management. So the nexus between the stamp duty and the brokerage fees and the finding of facts there is drawn extremely closely. And then if we turn over the page, first paragraph, counsel for the society, though they contended that the expenses of management were the same as the expenses of conducting, carrying, or running this business, yet conceded that some qualification must be introduced. And quite illogically, as it appears to me, yes, poor counsel for the society is going to have an awkward evening, admitted that there could not be included in such expenses the cost of purchase of the investments themselves. I do not know why not, for the acquisition of the necessary stock in trade would appear to be a first expense of carrying on a business. And in a sense, we'll see this repeated through their lordship's judgment. The concept of what constitutes management in the mind of their lordships here, that is picked up in Camas, is wider than perhaps the management that we might have in mind in perhaps contemporary parlance, but it goes to matters regarding the administration of the business, as we'll see in due course. Lord Reid identifies that the payment of a cheque, the writing of a cheque, is an act of management on the part of the company. And so the width of what their lordships identify as constituting management informs that which comes next. Lord Morton starts on page 357 of the report. He finds the expenditure was also not deductible. But again, starts off by recording the premise of his reasoning is from the basis that there had been a concession that the price of the investments themselves would not constitute an expense of management. That being the case, his lordship goes on to say, it's been common ground between the parties throughout all courts that expenses of management do not include the price of investments bought by the society in the course of its business. Now it is clear that the sums now in question are not part of the price, for the price of an investment, purchased or sold, is the sum which is paid by the purchaser to the seller. These expenses are, however, so closely linked with the transaction of purchase that they may naturally be considered as items in the total cost of a purchase, which has been resolved upon by the management of the company, and not as expenses of management. This is the short and simple ground upon which the Special Commission has decided the case in favour of the Crown, and I have arrived at the conclusion, though with considerable doubt, that it is a sound ground. So the expansive scope of what constitutes an expense of management begins both of these judgments. And then, in fact, for your notes, my Lord Morton rejects the narrow words of expenses of management that are put forward by the Attorney General. He endorses what Lord Somerville says, and Lord Somerville is, with respect, important in this analysis, which we'll come on to in a moment. Lord Reid, in the minority, finds that the taxpayer's appeal should be allowed in respect to the brokerage fees, but not the stamp duty. And his judgment starts on 358. So he's even more expansive than their lordships as to what constitutes expenses of management. And if we look at the bottom of page 359, you can see the passage where he says, moreover, here we are. Sorry. I cannot believe that this form of drafting, expenses of management, including commissions, could have been adopted unless it had been thought that commissions were at least so closely analogous to expenses of management that, without the words in brackets, it would have been doubtful whether commissions were or were not within the ambit of the words. That seems to me to be sufficient to negative one argument for the Crown, that expenses of management only exclude expenses included in making managerial decisions. Commissions arise from individual cases, and if expenses of management had this narrow meaning, they would differ so radically in their nature from commissions that I cannot see any reasonable person merely bringing them in a parenthesis. Moreover, even without this consideration, I should find it very difficult to accept the view that no part of the administrative expenses involved in dealing with individual policies, from receipt of a proposal to final payment of policy monies, was to be regarded as expenses of management. So we don't have the word commissions anymore. That's been removed. But the point I believe that His Lordship is making is that when one comes to the core content of what's meant by management expenses, there was no difficulty in his part in identifying that even in dealing with policy, these are expenses of management as a matter of general principle. And if we look over the page, you see that, not quite codified, His Lordship says this, looking to the, it is in the middle of the page 360, looking to the purpose and content of the section, it appears to me that the phrase has fairly wide meaning, so that, for example, expenses of investigation and consideration whether to pay out money, either in settlement or a claim, or in acquisition of investment, must be held to be expenses of management. And if you look down the page at the bottom,
just read the words, a bit in the middle.
Yeah, of course I can.
Admittedly, the price paid.
Yeah, admittedly, the price paid for an investment is not an expense of management. Admittedly, that's a sort of antiquated. It means by concession. It's not a price of expense of management. And counsel for the appellants did not and could not reasonably withhold the admission that a sum spent on enhancing the value of a trading asset is not an expense of management. I do not think it is practicable or reasonable to draw a rigid line between payments which enhance the value of the assets and payments which do not. For example, if a call is made in respect of shares not fully paid, paying the sum necessary would not be an expense of management, although there have been cases where shares remained of no value after becoming fully paid. It seems to me more reasonable to ask, with regard to a payment, whether it should be regarded as part of the cost of acquisition on the one hand, or on the other hand, something severable from the cost of acquisition, which can properly be regarded as an expense of management. If that be the true test, then I have no doubt that the sums paid for the stamp duty were not expenses of management. The companies could not acquire and hold shares without making these payments, and no matter of management was involved any more than it was in paying the price due to the seller. Buying the shares and paying the duty were inseparable. I do not say that no payment of duty can be an expense of management. For the cost of acquisition of checkbooks must be an expense of management, whether it arises from stamp duty or not. But where payment of duty is a necessary of consequence of something which is not itself an expense of management, I do not see how the payment of duty becomes an expense of management. So even at its lowest point, Lord Reid, on this material, is identifying a width of management, expenses of management, that in my submission cannot survive. It leaves very little room to manoeuvre if my learned friend's formulation or interpretation of section 1219 subsection 3 it holds.
Well, that may be so, but
It may be so.
if that's the effect of what Parliament has chosen to enact, then we must give effect to that. Isn't the fundamental problem with looking back to 1958 through the lens of what has happened subsequently? At least two major legislative changes have occurred since then. One is, as I understand it, the introduction of CGT in 1965. And then the amendment to this expenses regime in 2004, which we now find in subsection 3A in the 2009 Act. No, their lordships were not, certainly not at the front of their minds, was the question, is this capital or revenue? Because that wasn't an issue then.
No, my lord. But isn't it, I believe, I accept that there have been legislative changes, and in a sense the purpose of this appeal is to ascertain what the effect of those changes were. However, what there have not been is any legislative changes on the face of the language, expenses of management, as to what is meant by that.
True, but the structure of the Act, it may be said, is that you have this set of provisions saying these are in principle the type of expenses which are deductible. But now there's a carve-out, maybe a large carve-out, maybe a small carve-out, but there's certainly a carve-out for capital expenses. And Mr. Ewart's basic submission is, you don't need to worry too much about whether it would have fallen within expenses of management as per Sun Life any longer, because if it falls within capital, end of.
But in those circumstances, then if one takes the ECC quarries in what case one takes Sargent and Ayres, it's very difficult to see what a business which consists in acquiring, holding, managing investments can possibly identify as being expenses of management which are not at that 64,000 feet level of abstraction identified as falling on the wrong side of the line. I mean, effectively it renders, I'm finding it hard to identify a basis upon which to see what expenses of management survive this. My lord.
I mean, I see that argument. Just coming back a moment to page 199 of the report, you say that Lord Reid is identifying the width of management in a way that leaves little room for manoeuvre if Mr. Ewart is right. Now, I'm probably being obtuse. Why is that?
Well, Mr. Ewart, as I understand, if one thinks back, I'm going to make some submissions in ECC in what case, because with respect, I'm not sure one can actually pull out of the case stated precisely what it was that the expenditure there in question was for and the period in which it was born, because that isn't the basis upon which that decision was decided. But taking at its highest level, I have a note of exactly how the formula was put yesterday by my learned friend, which I'll come to in due course. I understood the submission to be advanced in reliance on that and on Sargent and Ayres, that those costs of investigating in the context of Sargent and Ayres whether or not to go into business in Australia would be excluded as a result of my learned friend's case. And if that's right, well, that's a long way from something, in Sun Life, their lordships were under no doubt. The only doubt they had was whether or not the concession that actually buying the investment was not an expense of management. Consideration of it, I think their eyes would be on stalks at the suggestion that that was not an expense of management.
I mean, I see that, but I'm not sure why that helps you in this context, because it just means that the exclusion would have a role. I mean, the wider you make expenses of management, the more role there is for the exclusion to play a part.
My lord, I accept that, of course, but in circumstances where their lordships begin from the position that the object of this relief was to tax the businesses there in question on their economic profit, effectively, and that's a point that's picked up later in due course, I would say that the court should be careful with respect before reaching a conclusion which, on the facts of this case, will result in a conclusion in which my clients are not taxed on the basis of their economic profit, because that upends the purpose as then identified. I still have to meet my Lord Justice Singh's point. Well, the purpose may have changed over time, and the scope of that may have changed over time, but simply in terms of the building block of this antiquated relief, which is of long-standing utility to investment companies, it would be a startling conclusion if the introduction modestly announced in section 1219 subsection 3 was such as to rewrite entirely the scope of the expenses of management code.
We also need to remember a very unusual feature of the present case, which is that your client, as you have already reminded us, didn't make any disposals at all, and therefore wasn't within the CGT net. On the other hand, in all normal cases, I say all most cases, the contrary would be the case. I mean, the asset in question that's being disposed of would be subject to the CGT regime, and Parliament has chosen, for reasons which we must accept as being representing the law, that only a narrow category of allowable expenditure is deductible. In that respect, trading companies are in precisely the same position. And I can't at the moment see why we should be, as it were, feeling your clients are hard done by, just because they're in the same position as everybody else.
My lord. On that particular point, with the greatest respect, I cannot accept the premise because this is an investment business. It doesn't necessarily involve itself in acquisitions and disposals, indeed, and I don't know if one looks at the findings of fact regarding the evidence the tribunal heard about what this investment business does and other businesses. I'm not sure that one can simply assume that it's hard luck that we didn't sell an asset and therefore we don't have the right type of expenditure. In my submission, the obvious construction of the code in light of the history of the meaning of expenses of management was that it was intended to allow exactly the cost of considering what to do with investments, whether to, and when one look at the findings of fact as to what the expenditure was incurred on, advice that was used in decision making, and some, etc., I would submit that's the classic type of expenditure that's incurred by investment companies.
But, I mean, the cost of reviewing one's portfolio of investments, Mr. Ewart was inclined to accept yesterday when I put it to him that sort of intuitively feels like revenue expenditure. I don't think anyone is going to dispute that. And we're dealing with a very different case, which is whether you come within the principle that once a disposal of an asset has been decided upon, you move into the territory where it's capital or not.
Well, my lord, yes, but of course, on the question of whether or not a disposal is being decided upon, those are exactly the function of reviewing investments every day when one reviews.
Well, no, I don't accept that. I mean, there's a great difference between just reviewing generally with advice from stockbrokers and other experts as to whether your portfolio is currently balanced in the right way or whether it needs the weighting, shifting, changed, all that kind of issue, on the one hand, and actually making a positive decision, as in the present case, to get rid of a loss-making asset.
Well,
that's the critical feature of the present case, is it not?
Well, if it is, my lord, then in due course I will in any event take your lordship to the findings of fact that are made in relation to that, because the weight which is put upon the, in inverted commas, strategic decision in 2009, I submit, is not borne out by the terms of the findings the tribunal made in light of a significant amount of oral evidence and witness evidence that was before it. And what has happened, in a sense, is that the quality or nature of that decision has been elevated, understandably, by my learned friend, to draw a line. But in my submission, that's not borne out by the facts that are made.
Of course, we'll listen carefully to your submissions on that point, and I'm not trying to preempt it.
No, of course.
Yeah.
If this were a trading company, would the cost of acquisition of checkbooks be capital or revenue?
It would depend entirely upon the nature of the business itself, my lord. Right. I mean, if it was selling checkbooks, it would be a revenue expense.
Yeah, but let's say trade is something else. But in order to pay people, it needs to have a stock of paper clips.
It would be a revenue expenses. Those are ordinaries are incurred probably every day of the week.
Yeah, exactly.
But when one comes to look at the evidence as to the nature of the services that were received here, the fact that they were, with respect, brought in from outside is, as the tribunal identifies in its findings of fact, somewhat disguises the fact that actually these are the sorts of activity that Cole was doing every day of the week. This was not.
That I understand.
This is not a portfolio being managed.
That I understand. Yeah. All I'm suggesting is that the fact that we now have to look at things through the lens of capital or revenue, which is not something the courts have ever had to do before, either in Sun Life or Cannan, doesn't necessarily mean that there is no scope for the operation of the expenses of management scheme.
Oh, my lord, I absolutely accept that. I must accept that. It doesn't render it. But what I take issue with is that in my submission, I can draw to the court a neat line as to the categories of expenditure that are excluded by Section 1219, subsection 3. But my learned friend leads with examples, and those examples do not assist in identifying as a matter of principle what the exclusion is designed to do.
We've taken you a long way from Lord Reed at page
No,
199.
My lord, I'm sure everybody is grateful that you have to. Just finally on this, Lord Keith endorses Lord Simon's, Lord Somerville. And Lord Somerville is useful. I don't think I need to take you to all of it, because he provides a very helpful exegesis of what it is that the relief, when it was first enacted, was intended to achieve. And it's extremely clear. And then, again, I think I need not take you into all that, my lords, save to identify at the bottom of 201. Unaided, I think, have come to the conclusion that the items here in question were expenses of management. The buying and selling of securities is clearly part of the business of the company and a function of management. No one would dispute that it is proper to buy and sell on the stock exchange. Might not the expenses of doing so be said to be expenses of management? It is plainly a possible view. And then he finds, with some hesitation, that they should not be treated as expenses of management, given that they were, in his words, an integral part of the purchase price, being a direct and necessary part of the cost of a normal method of purchase. If we might now turn to Camas. And tab 24 of volume 2. If I could ask the court please to turn to the judgment of Mr. Justice Patton first. And that starts on in the report page 659. I'm very aware that the court has looked at the facts of this, but I wonder if I might just draw to the attention of the court a few facts which I submit are quite significant to the analysis. Camas was the owner of the whole of the issued share capital of Camas Holdings, together with loans, £68 million to Camas America. loans of 18 million to Camas Holdings, with a loan of £1 million to Camas Overseas, and some cash at the bank. The activities of the group included quarrying, the manufacture of asphalts and precast concrete products used in the construction industry, road surfacing, and associated services. In or about 1995, Camas was looking to acquire new investments in the same market sector as that in which the group operated, to save costs and utilise its own management experience. In about March 1995, Camas identified the Barden Group as a possible target, either for merger or acquisition, but ultimately no transaction occurred. From April, Schroders were engaged. In November 1995, the board of Camas approved a proposal that the acquisition of Barden should be pursued. So, as it were, an in principle approval pursued. From December 1995 onward, board meetings with lawyers and bankers were held to discuss the deal. And on the 19th of December, an offer was made for shares. On the 20th of December, the offer was rejected and the project came to an end. If I could ask the court, please, to turn to paragraph 14 of this. And to look at the nature of the expenditure that was the subject of the claim there in question. Schroders' fees relate to their work as the financial advisor to Camas in respect to the takeover. This included advice on strategy and tactics throughout the process. Includes the formulation of alternative strategies in relation to a possible merger or takeover, advice on the methods of financing any offer, with an appraisal of the financial impact of successful offers for Barden over a range of prices. I've already referred to their attendance at board meetings and other meetings and to the papers which they prepared. Warburgs, as brokers, also gave advice on strategy, as well as carrying out an analysis of the register of Barden shareholders. The fees of KPMG relate to a comparison of the financial performance and accounting policies of the Camas and Barden groups, a review of the benefits of integrating the two businesses, and a review of the profit forecast for the Barden group. They also carried out an assessment of the borrowing requirements in the event that the takeover offer succeeded. Clifford Chance advised on the impact of the proposed transaction of competition laws and what information would need to be submitted to the Office of Fair Trading. They also advised on the information that would require to be included in any circular and gave advice to the directors of Camas on their responsibilities under the City Takeover Code and the Stock Exchange Yellow Book. Together with Schroders and Warburgs, they attended a number of board meetings. Sherman and Sterling advised on the US antitrust laws, the impact on US securities laws. FPC Greenaway are printers, and their services related to printing, the offer documentation, listing particulars, circulars to shareholders, and some press releases. All of this expenditure was charged by Camas to the profit and loss account in accordance with commercial accounting practice. If we turn on to page 16, paragraph 16, Mr. Justice Patton identifies what the Special Commissioners found to have been the object of the expenditure. I'm acutely conscious that my Lord Justice Henderson knows this inside out. But
well, I've had nearly 20 years to forget it. Please don't assume.
The object of the expenditure referred to in paragraphs 35 to 37 above, viewed as a whole, was to take the company as potential offerer through the 3 steps outlined in Mr. A.J.H. Reed's evidence, to acquire a target company, particularly one which, like Barden was quoted, and had a widely owned share capital, required a full appraisal. And then they go on to explain what the object of the expenditure was. And then if you turn over the page, paragraph 50, he recites also the finding that relevant to the present issue, we find that all the expenditure in issue here relates to Project Barden in the sense that it concerned the proposed merger with or acquisition of the whole of the issued share capital of Barden, the means of achieving that result, and whether or not to proceed with that bid. And I'll come on in due course to draw parallels between the expenditure in our case and that here in question. And in paragraph 17, Mr. Justice Patton says this: "These findings of fact are not open to challenge on appeal. They do, however, accurately analyse the role of the professional advisors. The essential points seem to be that all the expenditure was relevant and necessary to Project Bardon. B, that all the costs, apart from the printing costs, related to advice given to assist the board of CAMAS in making decisions about a possible bid. And C, that most of the expenditure also had the dual function, providing the necessary starting point for a bid, and would have had to be incurred by a potential bidder in mounting a bid." Mr. Justice Patton then goes through an exegesis of the origins of the relief and an explanation of how it interacts with the capital gains tax code. I don't think I need to trouble the court with that further because you looked at it yesterday. But if we could turn to 669. There are 2 points that are really being advanced here on behalf of the Crown. Expenses of management do not include expenses wholly attributable to a particular acquisition, and in any event, Section 75 does not include the permit deduction of a capital nature. We then turn on to 673. And the bottom thereof, Mr. Justice Patton deals with the capital revenue question first. We don't need to look at that at this moment. And at the bottom of page 673, we see his reasoning in relation to the main issue on appeal, whether the fees were dispersed as expenses of management. He takes the through Sun Life. And in paragraph 36 summarises the position as follows. I've quoted at some length from the speeches in Sun Life because both parties accept that they contain the law that I have to apply. Mr. Prosser, QC for CAMAS, invites me to accept the correct test, the question posed by Lord Reid as to whether the costs under review should be regarded as part of the cost of acquisition or something severable from it, which can properly be regarded as an expense of management. And the Crown has accepted in its skeleton argument this is the true test, or at least the most helpful formulation of the test in the present context. I agree with that, but the real difficulties, of course, arise in its application to the facts. And he goes on to make that Sun Life was an easy case to decide. And he looks at Hurst, which I won't take you to now. And if we then go on to the reasoning on page 552, paragraph 41. It's evident from paragraph 59 quoted above that the Special Commission has accepted that all of the professional services were rendered so as to enable the Board of CAMAS to decide upon and prepare for the bid. I'm unable to see the materiality of any distinction between routine investment decisions and a proposed major acquisition of the kind involved in this case for the purposes of determining whether or not the expenses involved were expenses of management. The only difference is in the amount of preparatory work and advice which is generated, but the latter is no less a management decision than the former, and the Special Commissioners appear to have accepted that. Then he goes on to summarise the Sunline test as follows. In paragraph 43, the speeches in Sun Life indicate that the correct approach is to draw a line distinguishing between management expenses and expenses or costs which are properly to be regarded as the costs of acquisition, i.e. the purchase price. And in that regard, he recites the reasoning of Lord Reid, and expenses, to use Lord Reid's words, severable from the cost of acquisition if objectively viewed, it is not part of the purchase price. That is a matter of judgment in every case. But it does not follow merely because expenditure which predates a possible or actual acquisition was a prerequisite to, or to use the Special Commissioner's words, directed at the acquisition, that it falls automatically to be regarded as the costs of acquisition. And in due course, I'm going to submit that in substance, my learned friend's case appears to attempt to, at this stage of the analysis, in identifying whether or not our expenditure was expenses of management, leaving aside the capital question, seeks to try to resurrect that test here. If you apply a cut-off line at the point at which the, in inverted commas, strategic decision is taken, a long time before a potential purchaser or mechanism or any of that is identified to sell it, it would fall the wrong side of the line drawn by Mr. Justice Patton. If we could then turn on to the judgment of Lord Justice Carnwath, as he then was. And again, we've looked at much of this. But if I could draw attention in particular to the summary at paragraphs 20 and 21 of the judgment. In the extract cited above, I've emphasised the words which seem to me best to encapsulate the effect of the various judgments. All stress the closeness of the link between the expenditure in that case and the process of acquisition, part of the expenses of purchase, an integral part of the cost of acquisition, items in the total cost of a purchase which has already been resolved upon, a direct and necessary part of the cost of a normal method of purchase. Conversely, expenditure is not excluded merely because it relates to activities carried out in contemplation of acquisition. Lord Reid said that the expenses of investigation and consideration, whether to pay out money in the acquisition of an investment, should be treated as expenses of management. And of course, in due course, I'm going to submit that so in this case, the expenses of instructing Deutsche Bank, PwC, and De Brauw were investigatory. And that's the findings of fact that were made by the FDT. And at the end, interestingly, I think Lord Justice Carnwath is approving Mr. Pross's submission by saying that what is excluded by Sun Life is expenditure on the mechanics of implementation. I think, with respect, that's an important point, because the way in which my learned friend's skeleton is produced, it's not a criticism, but there's a temptation to concertina the words costs of implementation, but actually it's not cost of implementation that fall on the wrong side of the line according to Camas and Sun Life. It's cost of the mechanics of implementation. And with the greatest of respect, when one comes to look at what the expenditure here purchased, the advantage, the services that were required here, it cannot sensibly be described as being the mechanics of implementation. My lords, in my skeleton argument, but perhaps just to try and tie an end to this law, I've tried to identify, my friend and I have tried to identify some principles regarding the what the authorities say regarding the expenses of management question, before we get to the questions of capital. And you'll find those in my skeleton argument at say my skeleton argument. I should hasten to add that my learned junior risks a very severe injustice to my learned junior.
This is paragraph 16 onwards.
That's correct, my lord, yes. I don't think I need to ask to read those out to the court in the interest of time, but I say those are the propositions that one can draw from the authorities. My Lords, what I propose to do now is to deal in some detail with the facts as they were found. I would hope to have that done in time for the short adjournment, but please don't worry, as it were, if I seem as if I'm taking an awfully long time about it. I have budgeted for it in my time estimate, and I'm sure that my submissions, I hope, can be dealt with comfortably to leave my learned friend time to reply before 4 o'clock.
So we can put the authorities away.
Yes, my Lord. What I'm proposing to do, if I may, is to take you through the decision. I won't take you through it chronologically in some respects. I'm going to dart back and forth because in my submission, it's easier to understand what the judges below are deciding if one tries to group the findings of fact in categories. And so if there's a lot of turning backwards and forwards, I apologise, but it's an attempt to try and codify where the relevant findings can be found. A few points to make at the outset, if I may. Before the FTT, had a 5-volume hearing bundle, and it heard witness statement from 3 witnesses, on which the witnesses were cross-examined. There were detailed notes on evidence that were produced by the parties below. There was also an agreed statement of facts. Now, the notes on evidence are not before you, because in a sense they're redundant once the findings have been made. The agreed statement, findings of fact is in the bundle, should you wish to refer to it, and you'll find that in core bundle 2.
Do you mean the supplemental bundle?
Sorry, the supplemental bundle. Actually, my Lord, I think it's... This is, I apologise, my Lord, this is exactly supplemental bundle.
Core bundles would be better. Oxymoron. 2 core bundles.
Well, yeah. You also saw, you were taken yesterday to the excerpt that the FTT recorded, interestingly by my learned friend, in which he noted Mr. Defert's evidence. You'll see that the FTT itself records this at 125. Mr. Defert commented that documents in my bundles probably represented less than 10% of the documents generated in the transaction. Some were undated and some were drafts, so it can be difficult to pinpoint exactly when something happened. He also emphasised that there would have been a large number of some types of documents, such as timetables, step plans, and sale progress and presentations. I say that really to premise what I'm about to say regarding the findings of fact, which is the sheer richness of the material regarding the nature of the business here in question and the use to which it was made, and to explain in some ways quite why the exegesis and the findings, the detailed findings by the FTT, were carefully made. It had an enormous volume of material in front of it. So the first category of facts that I would like to take the court to is an explanation of the findings of fact that were made regarding the nature of Cole's investment business, because both on the terms of the expenses of management issue and in due course when it comes to the question of capital, clearly those questions must be asked in the context of a given business, and the FTT was mindful of that and made detailed findings on that. So, paragraph 15 Cole was and is a substantial intermediate holding company holding the group's investments outside the USA. At the 31st of December 2009, the company's book value was 1.3 odd billion. Its investments included shares in and loans to companies in the UK, Spain, Canada, Norway, India, and Germany, and other European companies. Just to illustrate that, we might have a look at the financial statements of Cole for one of the periods. And if we could turn to the supplementary bundle. tab 60 thereof.
Sorry, which tab?
Tab 60, please. I'm afraid the printing is not the easiest to read, but there's an account of the activities that went on during the course of the year. But actually, one can take what I need for present purposes really from page 316. And if you just have a quick look at the list of principal subsidiary undertakings there, you can see the width of the activities, the enormity of the investment business that's carried out by this company.
I quite follow that. It's not an investment company of what one might think of as a normal kind. I mean, this is a group with various subsidiaries with different businesses.
My lord, well, the normality or otherwise is a question actually that the FTT identifies. It is not, in my submission, unusual. It's just a different type of investment company. Multinational groups of this company regularly have investment companies like this. It may not be what one has in mind in the sense of an investment company, in the sense of a portfolio investor.
Yes.
But it is nevertheless accepted and always has been accepted.
I quite follow that.
And that must be particularly so now that we have that extended definition.
Exactly, my lord. Yeah, exactly. But my lord, the point is entirely important, of course, because when it comes in due course to analysing the question as to whether, if these are expenses of management, are they excluded by the capital, we need to look at the nature of the business that's being conducted here in question, which, as your lordship says, is different to a portfolio type investor.
Yes.
And indeed, we can turn to what the FTT found on this, having heard evidence on rights. If we look at page 118, sorry, page 216.
In which one?
Of the FTT decision.
Paragraph 2.
Paragraph 216.
Oh, right.
Of the FTT. The FTT made some observations of its own regarding what an investment business does, which are informative. An investment business does not consist solely in the purchase and sale of shares. The aim of an investment business is to maximise the value of and/or returns from its investments. In the context of a holding company, whether the top co of a group or an intermediate holding company, its investments are its subsidiaries. Whilst Howden and Dawson, the two authorities that the tribunal looked at, draw a distinction between expenditure on the investments and expenditure on the investment business. In principle, expenditure which is directed at maintaining and improving the value of a subsidiary or better enabling it to pay dividends or repay its debts would normally be expenses of managing the investment business. Then the tribunal goes on to comment on Howden. But what I mentioned there is not the proposition of law, but simply the tribunal's understanding of what it was that this business was doing and what its daily bread was. We see more of that if one turns on to page 218. And in paragraph 218. And in fact, this actually traverses the point that my Lord Justice Newey just made. At the bottom of the page, the investment business of an, inverted commas, ordinary investment company, such as a unit trust, might consist mainly in buying and selling the investments. But there is more to the investment business of a holding company of a group of operating trading businesses. In this context, the management of the holding company's investment business includes the procuring of transactions by the company's subsidiaries, where those transactions inure for the benefit of the holding company by preserving or increasing the value of the subsidiaries or enabling the subsidiaries to provide better returns for the holding company, or, as in this case, enabling the subsidiary to repay loans it owes to the holding company. And there are more of these, we'll carry on. Paragraph 312. Coal's job, essentially, is to preserve and realise value for the shareholders of Centrica. As in this case, that may require itself to divest itself of a particular investment. And it's not just a question of keeping or selling an investment, it is a question of realising the maximum value from it. In an ideal world, Coal will have sold the shares in Oxio BV, but the world is not ideal, and after a torturous 2 years of working towards a transaction, the value was realised by restructuring the Oxio group, selling some of its businesses, and procuring the repayment of the substantial loans that Coal had made to Oxio. And then the judge says, in this context, investment and investment advice is not just about whether to buy or sell, but also how to buy or sell or otherwise realise the maximum value from an investment. If we turn on, please, 424. I've already commented that investment management, especially in the context of a holding company of a trading group, involves not just a consideration of whether to sell or buy an asset, but how to sell or buy, or more pertinently, how to realise the maximum value from an investment, which, as in this case, might not involve selling the investment at all. I'm afraid there are a few more of these, but I think they are very important because they set the context of the reasoning for the judge in due course. Paragraph 432. The investment decisions which an investment company like Coal has to make are not just whether to sell an investment, it also needs to decide who to sell it to and how to sell it. If it cannot be sold outright, it needs to decide how otherwise value can be realised, and how much value it needs to obtain, or whether the asset should be retained at all, and improved or wound down. All these decisions are management decisions, and the cost of advice and assistance in connection with them will be expenses of management of the investment business. Now, if you could turn back, please, to paragraph 36.
The new heading, or the same?
Same heading, I'm afraid, my lord. Yep. Not quite done yet, but it's a slightly different flavour of the same heading, in that now I'm going to identify some findings of fact that go in my submission to identify how the group operated in practice. So we've seen the scope of its business and what sort of things it was doing. How in practice did it operate? Strategic decisions for the group were made by Centrica. This was facilitated by various central teams who would provide advice and support for the group in areas such as legal, tax, accounting, regulatory matters, finance and mergers, and acquisitions. Individual companies within the group did not have their own teams dealing with these matters, but would be provided with support by the central group-wide teams. Most of the employees of the group were employed by a small number of companies within the group, and many of the subsidiaries, such as Coal, had no employees of their own. The operating companies did, of course, have their own employees. The directors of the subsidiaries would be employees of Centrica or another company, and would often, as in Miss Redcliffe's case, be a director of several companies. Paragraph 56, please. Mr. McCord explained it was not strictly necessary to employ advisors such as investment banks, accountants or lawyers to carry out transactions, and Centrica could and did carry them out using their own in-house teams. But then, he goes on to say, in large and difficult transactions such as the present one, an investment bank would be brought in because of a lack of bandwidth to do the heavy lifting. In other words, a transaction like this involved a great deal of work over an extended period, and Centrica staff did not have the capacity to deal with it. Mr. McCord also commented that using an investment bank was a standard procedure, and having a respected name as a lead advisor would give credibility in the market, and they were used because they were likely to obtain a better outcome than if the company had used their own resources. He also made clear that Centrica was deeply involved in the process and was the decision maker. We're going to come back to look at what Deutsche Bank's role was, because there's some comments that follow now that are obviously material to the findings about what was procured as a result of the expenditure. But if I may, I'll deal with those when I come to what the fees were paid for. If we can now turn to my next theme, which is the history of the Oxio investment and the managerial decision-making in relation to it. And the principal findings of fact in this are set out between paragraph 16 to 29. You've seen already that the finding at paragraph 24. Clearly, the board of Centrica had decided in June 2009 that it wanted to sell the Oxio business and it was taking steps to do so. 26. The problem for coal was that a prospective purchaser would not necessarily want to buy all of these businesses. This is compounded by the fact there are problems with management and financial controls which made a share purchase unattractive from a buyer's point of view. But then, if one can turn forward to paragraph 324, the nature of that decision, the findings that are made regarding that decision in June 2009, are the subject of a number of other findings of fact that, in my submission, must be read with them. And to paragraph 324, Centrica undeniably made a strategic decision to divest the Oxio Group in mid-2009, and one might say it had a firm intention to dispose of the business. There is, however, a world of difference between making that kind of strategic decision and getting to a point where a specific decision is made to enter into a specific disposal transaction. Equally, if not more important than the decision whether to dispose of the business was the decision how to dispose of it, or indeed whether it could be sold at that time. And then if you turn to the bottom of paragraph 326, the transaction which was finally agreed was the result of a long and hard negotiation which required many managerial decisions. Centrica was not prepared to sell at any price. It needed to achieve a certain level of proceeds, as evidenced by the fact that it considered trying to cure the fundamental problems in Oxio business, so as to try and sell later at a better price, and by the fact that it rejected at least one and possibly two offers from Bioneco before approving the deal on the 22nd of February 2011. 328, there was no prospective purchaser in view at the outset. Part of Deutsche Bank's role was to consider the buyer universe, and this expanded and contracted as the process progressed, with 10 or more potential buyers in the energy sector being put forward at various times, and even private equity investors being considered. If one turns back now, please, to paragraph 77, in August 2009, Deutsche Bank produced a presentation on possible structures. Centrica's preferred option from the outset and throughout the course of the transaction was to achieve a going concern of the Oxio shares. Even at this stage, it was thought necessary to consider other options, and the paper also considered the assignment of customers, which would be more attractive to a buyer as it enabled them to cherry-pick the assets they wanted, the retention by Centrica of working capital, and the transaction which carved out the Richmond business and or the pipeline capacity. 78. As the process evolved in the course of 2009, the possibility of a share sale began to look more difficult as Centrica gained a greater understanding of the problems in the Oxio business. Uh, 79. There's a bit more background to Oxio. Explaining some of the difficulties that were there that were a barrier to any sale that needed to be resolved. Accounting irregularities, lack of hedging, poor risk management, unidentified tax exposures, and no clean audit opinion. I'm taking the court through this laboriously because in my submission it repays very careful reading because it casts light upon what's meant by a strategic decision. This is not the type of decision which forms the dividing line between what constitutes expenses of management as a matter of general principle or otherwise as drawn in Sun Life and Camas. This is not simply press a button on a dealing screen and sell your Amazon shares. This is an enormous investment with all myriad of problems and things that need to be considered. That it may well be a decision made that we'd like to get rid of it, but for the reasons that will become even more vivid as we look through it, these are the advice that's received from the cost tier in question were not the mechanics of implementation of a decision that were made in June 2009. If we could then turn to, we've looked at 72, we turn to page, paragraph 121, please. And this deals with the strategic decision. There were 4 key events that the tribunal identifies. The first was a strategic decision to sell the Oxio business, which was taken in June 2009 by PLC. One assumes that the accounts of a public company were correctly prepared, that it was considered that Oxio could correctly be presented as a discontinued business, despite the fact that Centrica knew the business had problems, as it had made unexpectedly large losses, and the audit opinions for 2008 and 2009 were qualified. From the outset, Centrica's preferred option was to achieve a clean, going concern share sale, although as the transaction progressed, this option became an aspiration rather than a likely outcome. It is clear from an early stage it was recognised that an entity sale might prove difficult, and there are times when it was thought they would not be able to sell the business at all. And if you look at, just to qualify that a little bit further, one turns on now to 218. We looked at the end bit of it as to what an investment business does, but it's worth looking now at the facts that they find regarding what was going on at the period here in question. The initial intention was to sell the shares in Oxio BV. If this had happened, no doubt HMRC would have agreed that such a transaction was part of the management of an investment business. In fact, it became fairly clear fairly on that the sale of the shares was more of an aspiration than an intention. Although that aspiration continued until the time of an echo transaction, the evidence shows that consideration was, from an early stage, given to other ways of realising value from the Oxio business, and those alternatives continued to be considered. We heard that options included selling of assets of the business, rectifying the problems in the business with a view to a future share sale, and not selling the business at all, but winding it down. While Centrica had taken the strategic decision to exit the Dutch market, this was not something to be done at any price, The aim was to realise as much value as possible from the investment in a commercial way. And then there's the passage that we've looked at previously regarding this being, as it were, the ordinary management of its business. Paragraph 102 just to deal with the submission that my learned friend made at the outset regarding the significance of its designation for accounting purposes as a business held for sale. With respect, that needs to be read with some care, because obviously the test for accounting purposes as to whether or not a business is held for sale is a different one as to whether or not for legal purposes. But in any event, it's qualified, as the tribunal comes on to find. Despite the declaration in Centrica's 2009 half-yearly accounts that Oxio was now a discontinued business for sale, with the technical meaning set out in paragraphs 22 and 23 above, an extract of a minute from a Centrica board meeting held on the 7th of May 2010, so nearly a year after the decision that my learned friend hangs his hat on, states that the sale process for Oxio had been put on hold to allow the local team to focus on the work required for completing the 2008 and 2009 statutory audits. And then paragraph 103. If I could just ask the tribunal, you looked at this yesterday, so I don't need to read it out.
I'm sorry, which paragraph?
Paragraph 103, my lord. This is the deep dive.
Yes.
We will look at this again when we come to look at what was the advantage procured for the expenditure here incurred. But the key point is the sentence: the purpose of the report was to enable Centrica to understand just how bad the problems were and to inform their decisions about the options available in the context of a sale, and indeed whether the problem was so bad that the business was unsellable. Then another finding in paragraph 104 regarding the accounts, and the last sentence is significant. Mr. McCord admitted that the M&A team had had private discussions with members of the board about whether the sale process should be put on hold or abandoned, given the issues. Just to finish the timeline briefly, paragraph 93. So paragraph 90. Although an initial and disappointing offer had been received by Eneco in September 2010, work continued on the basis that the Eneco transaction might not succeed. Deutsche Bank maintained and regularly updated a list and analysis of potential buyers right up until the time the Eneco transaction was completed on the 24th of March 2011. Again, this is a very long way from the point of time of identifying the mechanics of implementation of the deal.
I'm so sorry, which paragraph is that?
Sorry, my lord.
That's my fault entirely.
It's paragraph 90.
Thank you.
I apologise. This is fairly laborious stuff, and I must apologise to it. But it is obviously.
Speaking for myself, I find it very helpful.
Oh, well, I'm grateful.
Thematic analysis, and having read it from beginning through to the end. The FTT took pains over its findings. It's understandable that it buried findings in different places, but actually one needs to look at them thematically to see how it. And I think on any view, whatever conclusion we come to, the FTT did a very, very careful and thorough job on the findings of that.
Precisely, my lord. Paragraph 91. On the 19th of January 2011, Deutsche Bank produced a document entitled Key Transaction Terms. This set out the headline terms, but many matters remained to be negotiated. Further indicative timetables were produced. So, far from being at the point at which we're instructing the printers to deal with prospectus and information to the market, we still, even the terms haven't been identified yet, let alone an actual deal. And finally, in paragraph 93, as Mr. Duffert indicated, they remained involved and in exploring the options right up to completion.
And the they is Deutsche Bank.
There is Deutsche Bank, my lord. I don't think I need to ask you to turn them up now, but just 3 further references on this, just explaining, making good that in my submission the FTT finds that really right up until almost the last moment, all options remained on the table as to what they were going to do with these businesses. Paragraph 127, there's a number of findings there, but the core of them is that for this reason, even after Eneco showed interest in acquiring Oxio and up to completion, Centrica continued to explore other possibilities. And it gives some examples of the other possibilities being explored very late in the day, in late 2010, as to what else it was thinking about. Paragraph 128, again, more of the same. All options remained open, and there are examples of a confidentiality agreement that's produced in draft with Eneco, which identifies different possibilities. Paragraph 130. This we might return to, actually. We might turn up 130. We've looked at this already. It's the corporate plumbing finding. Both Mr. McCord and his successor, Mr. Deffert, who were senior people in Centrica's M&A team, were focused on businesses as opposed to legal entities. They saw the role of the M&A team as obtaining the maximum value from the Oxio businesses in whatever way was feasible. They recognised that the lawyers would need to do some corporate plumbing to complete the transaction, but the aim was always to realise the value of the business. In the event, COHL received value not by way of the proceeds of sale of the Oxio shares, but by way of the repayment of much of the loans that had made to Oxio, following Oxio's disposal of its underlying businesses achieved by way of assets, sale and demerger. I take the court to that because, read in isolation, one might take the view that the reference to corporate plumbing there was simply putting the date in the SPA and signing this on it. But as I hope the passages I've shown the court are clear, this was some considerable mile away from that in terms of corporate plumbing. The entire, everything was up for grabs almost up until, up until February, as the tribunal found.
That's why I think you advanced on the tribunal, and the tribunal accepted your submission that the cut-off point was in mid-February.
Exactly.
Not I think you say because the important question is a temporal question. Rather, you say it's a substantive or conceptual question. At which point did what was going on flip from one side of Lord Reed's line to the other side?
That's precisely it, my lord. We don't say there's an arbitrary cut-off date. It's just that the quality of what was going on differed, because at that point in time in February, all of the ingredients necessary to fulfill the type of decision identified in Sun Life and Camas as marking the cut-off point calcified. But prior to that point in time, anything could happen. As is evident from the fact that if one charts the ambition identified in mid-June 2009 to what actually happened as a result of this transaction is that Centrica continued to own a power plant in Holland and continued to provide millions of pounds worth of financial assistance to it afterwards, which is not what had hoped to be established earlier. I say that in a... Centrica didn't own the power plant, it was one of the subsidiaries. May we turn, please, to the findings regarding what the advantage was that was secured as a result of the expenditure and what use it was put towards.
Is this your third?
My third category. And I'm going to take them in the order Deutsche Bank, PwC, and then De Brouw. My lords, one of the things that was, I have to say, from a layman's perspective, very interesting in hearing the evidence before the tribunal, which is, I will come on, I hope to make good, clear from the findings that the tribunal made, is that M&A teams and businesses such as Centrica and those here in question don't necessarily think of things in quite the same way as lawyers do. And so documents which on the face of matters look as if they're serving one purpose may be serving a number of different purposes. And the tribunal makes that very clear, in particular in the context of the PwC work that you see. So whilst with my lawyer's hat on, I might look at a due diligence report and think, well, that's for the benefit of the buyer. The evidence, as we'll see in due course, was, well, actually, no, it's equally for the benefit of Centrica. First of all, because you can't sell it without a due diligence report, but more importantly, because before you go to the market with it, you want to find out what's inside your shop, what's inside your bag. And that evidence was rich, as we'll see in a moment. Deutsche Bank. And sorry, the other point that I should make allied to that is that, perhaps obviously to most people, but Deutsche Bank don't simply deal with sales. They provide advice. Their role is not simply that of a broker. The services they provide are far wider than that, as we'll see under the terms of the findings. Starting, if we may, with paragraph 59 on Deutsche Bank. The starting point. A number of investment banks pitched for the work, and Deutsche Bank was chosen because they could demonstrate good contacts with energy companies, which might be interested in Oxio, had a good knowledge of the Dutch energy market, and the relevant team had a good track record. It was felt they could do a good job and provide the best advice about the options available for the future of the Oxio business. Paragraphs 63 to 72 onwards go through in some detail, and we've looked at this, the nature of the engagement letters as to what the Deutsche Bank were engaged to identify. I think it's important, just to be clear, to identify what's meant by the transaction is a defined term here. And the letters of engagement needs to be read quite carefully. There were three elements to the engagement, each described as a transaction. Letter stated, Centrica has engaged Deutsche Bank as its exclusive financial advisor in relation to the strategic alternatives for the Oxio customer supply base that may lead to a possible transaction through sale, whether by sale or asset sale, customer assignment, asset swap or otherwise, whether effected in a single transaction or a series of related transactions, the Oxio transaction. Its exclusive financial advisor in relation to the strategic alternatives for the Richmond 2 tolling agreement entered into by Oxio Tolling BV, the Richmond business, that may lead to a possible transaction in respect of the Richmond business, whether in conjunction with or part of or independently from the Oxio transaction. And C, its financial advisor in respect of the exploration of strategic alternatives for certain gas pipeline capacity in the Netherlands. The point I make there is that, read in isolation, a reference to transaction doesn't do justice to quite the width of the scope of the advice and services that this Deutsche Bank were engaged to provide. And read without looking carefully at the definition of it, it might imply a more teleological end to what had been envisaged at the outset than is actually clear from the scope of the services to be provided. The services are then described: financial advice and assistance in accordance with the transactions, which may include, if appropriate, advice and assistance with respect to defining objectives, performing valuation analyses, structuring, negotiating, planning, and managing the process of transactions. Deutsche Bank will, then it goes through a list of what it's going to do. Then at paragraph 66, there are two fees there in question. Just to make sure the court is clear, no claim is made by Centrica in relation to the additional incentive fee. So when it's talking about the contingent fee issue that you see below, it's the 2.5, if that makes sense.
But just to be clear, the Oxio transaction is tied back at 63A to the Oxio customer supply business, and then you had separately,
Yeah,
whatever.
exactly.
When we get to 66 and it says 2.5 million for the Oxio transaction, was there something separate for transaction B, so to speak, or was that it?
There was another, I believe there was another £1 million. I'll just check that. Oh, exactly. Yeah, my lord, there was no, it wasn't pinned to a particular transaction. It was a kind of thank you, if you will. And there's some evidence on
the
this.
potential, the incentivization fee is the thank you, is it?
Well, we would say it is a thank you, exactly.
Or whatever.
Yeah, for whatever happened. Yeah.
So there was no separate payment for
Richmond.
the Rhine Mound, or whatever you pronounce it.
I confess I've been calling it Richmond. But I
I
suspect
would like to
that's
say
probably
what
an
the
appalling
pronunciation
piece.
is.
The Dutch may take umbrage with me on that.
But there was no separate fee for that.
There was no separate fee for that. I mean, I think it was part of the incentivization fee, and there's some evidence on this because I think, if I may say so, the point that becomes clear as we'll look at the evidence is that these corporate service agreements are designed to cover a vast range of possibilities, and what Deutsche Bank wanted was to be incentivized to do something with this mess. I think that the second, the sweep-up payment, as we'll see the evidence comes out on, was in a sense a thank you for that.
Can I just understand the legal basis for the concession? Because that's effectively what it is. I think it's conceded by you that 66B doesn't fall within the meaning of expenses of management, whereas 66A does on your submission. And is the legal basis for that you accept that 66B is on the wrong side of Lord Reed's line?
My lord, it has never been it was never claimed by Centrica.
No.
So I don't go so far as to advance a legal submission in relation to it. Equally, it may be that it fell on one or other side of the line, but it's not actually the subject of the appeal. So if you would like me to, I'm happy to develop it. But it's not a concession I've made in the course of the appeal. It was never claimed.
Equally, on the face of it, I mean, a commercial entity will make a claim for an deduction if it thinks it's got a reason.
I think that's exactly right. Yes.
Yeah.
And if it chooses not to do so, it may well be natural to infer
It may be,
it's
exactly.
recognised that it's not likely to happen.
They quite properly thought it fell on the wrong side of the line.
Yes, yes.
And indeed, that would be consistent, my lord, with the submissions that I advanced regarding, at an earlier stage in these proceedings, regarding the contingency fee.
Indeed, yes.
Yeah. And the important point analytically for your submission is that the fees paid under 66A, although they may have been payable on the occurrence of the contingency, in fact, what they were was expenses on a continuing basis for work done.
Yes, I think one shouldn't, with respect, confuse the fact that the payment might not, that Deutsche Bank were willing to enter into an agreement not to be paid if nothing happened, right. With a test of the quality of it. Yeah. In the same way that a brief fee, which is contingent, is nevertheless a supply of services acting as an advocate before a court. If you happen to lose and don't get paid, the services were exactly the same. It may have been of a lesser quality.
Not in my experience.
We've
Sorry,
got to 1 o'clock, Mr. Rivett.
I'm sorry.
No, can I just check where we are on timing? Are we going to be all right if we resume at 2, or would it be prudent to start slightly earlier?
I hesitate to... I'm just anxious to leave my learned friend sufficient time to reply. I had budgeted... I think I can do the rest of the facts in about 20 minutes, if I may, but they are important. So that if I were to finish at 3:10, would that give my learned friend time to deal with his reply? Sorry, I'm sorry to talk across the court.
No, well, Mr. Hewitt has given confirmation. So if you can finish by 3:10, then that's fine.